Okay. It appears it is now up on YouTube.
Okay.
Although all I'm seeing, I don't see the plaintiff on here.
I see you, Judge.
Okay. All I see is Alex, myself, and Mr. Robeson on the YouTube feed. I don't know why that one might be.
Doesn't look like the plaintiff is appearing by video. I just see iPad.
Oh,
Yeah, I'm on, Judge.
okay. Okay. So it's just, okay. That's why I don't see it. You know, what I'm going to have to do is, I think, Mary, I close that YouTube video then, right? So we don't get feedback?
Yeah, just like no one should have it playing like in their background on YouTube. Otherwise, we will get that feedback, I believe.
Okay. Now, when I did that, I just shrunk my meeting down to a tiny portion.
Sorry, Your Honor.
You troublemaker, you. Let's see what we can do here. Doesn't let me, lets me move it, but doesn't let me. There we go. Okay. All right. Do you guys want a gut reaction to briefs first, or do you just want to go on the record with you? How do you want to do it?
We can go with the briefs, Judge.
Okay. In looking at the briefs, this is just a gut reaction. Again, argument may change my mind on these two issues. The first one, I think, dealt with mentioning the McDonald's case. If there were concerns that the plaintiff was utilizing it to inflame the jury as to the amount of the award, I would agree with the defense that perhaps that shouldn't be done. But here it's just a familiarity with a case where it appears that the award was out of hand. And does that mean that in every McDonald's case now, we're going to not listen to the testimony and not, follow through with what the plaintiff has to say? So in this circumstance, I would likely let the plaintiff ask about that, but Mr. Robeson, you'd be free to utilize it a bit too. Now you can't say to them, $30 million is ridiculous. We shouldn't even hear any McDonald's cases. So you see what I'm saying? Typically, if I'm hearing from the plaintiff that they want to utilize another case, it's because the award is so high and that's what they want this case to be, versus in this, don't turn yourselves off completely to my case just because these people did this on this case. So it's kind of the opposite of what we would typically get. And I would tend to agree with the plaintiff that, I heard about that case too, and I thought that was ridiculous too. So does that mean that we can't get jurors that will tear themselves away from that and just award nothing because all these McDonald's cases are ridiculous? Is that where you're coming from? Let me ask plaintiff's counsel.
Did you say plaintiff's counsel?
Right.
Okay.
Oh, yes, Judge. Like I said in my brief, it seems that you need to find out if there's bias, potential bias from just hearing about it, that it has there was some notoriety, there was some negative press about it. There was actually, I recall there was an actual campaign that went on for quite a while as a basis for why tort reform was necessary. So that would be the reason.
Okay. Mr. Robeson, I know that you had opposition to that, so I want to hear your whole argument when we do that. But I just got reactions to what I saw in the briefs. Then, as to the other issue, again, Mr. Robeson, I would tend to agree with plaintiff's counsel in that I think it was more than the doctor just saying, hey, he wouldn't have come into my office but for this burn on his leg. And I think he ties it more to the treatment than what you indicate, where it's just a coincidence that he was lucky he got his neck operated on because of this coffee spill. I don't think that's really what the doctor said. I know that was your interpretation of it, but I would tend to disagree based upon the reports I read. So those are gut reactions. Now you know where to attack on on each of these. But why don't we go on the record and we'll talk about them more in depth. Give me just a moment here. Somebody's ringing my doorbell. Perfect. All right, I do apologize. What timing for a FedEx delivery? All right, why don't we call it on the record then, Mary?
Okay. Case number 19CV000259, Aggrey Mutiva et al. Versus the MacPyles Corporation, doing business as McDonald's et al. Appearances, please.
Appearing on behalf of the plaintiffs Aggrey, Mutiva, and Mary Ambev Mutiva is Robert Erdman.
Good morning, Your Honor. Attorney Brandon Robison for the defendants.
All right, good morning. My understanding is the matter is set today on two separate motions. A motion to, I think that the primary focus of the motion was that the plaintiff's doctor did not tie cause to the coffee spill with the neck surgery. The other one related to McDonald's, the ability of plaintiff's counsel to bring up a case involving McDonald's where there was a very large award. I would note for the record, we did have a short off the record discussion where the court indicated just viewing the briefs themselves, just a gut reaction. But again, I'm not finished in making this decision, and I am going to listen to arguments of counsel before I get there. I think the focus points, though, have been laid out for counsel so that we can proceed on it. Why don't we start out with the McDonald's portion, Mr. Robeson? You believe that case shouldn't be cited at all in voir dire, is that correct?
Not only in voir dire, but in, opening argument, closing argument. Yes, Your Honor. And essentially, I think the prejudice is in trying to I'm not accusing Mr. Erdman of attempting to do this, but certainly subtly, the jurors are going to make that connection in their mind that, oh, here we go again. Here's another McDonald's case where they've injured another person with a burn to his leg. When are those people going to learn? We got to do what we need to do to drive home the fact that they got to control the temperature of their coffee. Something to that effect, Your Honor. And I don't necessarily know that that even needs to be said by Mr. Erdman in such explicit terms, but merely mentioning the infamous McDonald's coffee case will certainly bring that connection into the minds of the jurors. And quite frankly, it's an unfair connection because, as I pointed out in our brief, neither MacPyles nor American Family was involved in that case. That case involved different issues, specifically the one of punitive damages, which was what the jury awarded the very high award for. And it involved an issue of fact with regard to the temperature of the coffee and McDonald's practice regarding that issue, which is not a fact that's in evidence here. There's been no discovery about the temperature of the coffee or claim that it was egregiously hot or similar in its temperature to what went on in the Liebeck case. So, you know, there really is no purpose for bringing it up. And the prejudice of bringing it up to the defendants is that the jurors link in their minds this case to that one. Now, I've read Attorney Erdman's response, and I understand his concern is that he wants to address jury bias as it relates to tort claims. Certainly, you know, Attorney Erdman is a very experienced trial attorney, and I think he can figure out how to conduct a voir dire that gets to the issues of bias against tort claims, or whether a jury is shy or shocked by big verdicts, or whether it feels that tort reform is necessary without ever having to refer to that McDonald's case. I think he's certainly capable of doing that. And I think that the potential prejudice to the defendants here of unfairly linking them to that famous case with a huge verdict for the plaintiff greatly outweighs the plaintiff's need to mention it specifically in voir dire or at any other point in the case.
But, and correct me if I'm wrong, I thought the whole issue was the movement towards tort reform as a result of that verdict being ridiculous. That was my understanding, and I think that's what the plaintiff is arguing. And so, you know, I agree with you. I did hear that McDonald's had the and this is, it's funny because it's just through talking to people. You're right. It's not people involved in the case. I haven't read the case, but typically the reaction was, this is ridiculous. We need tort reform as a result of this crazy verdict. So it would actually favor the defense more than the plaintiff. And you're saying that that's fine with you. Let's just not mention it at all, right?
Well, Your Honor, I hear where you're coming from, and off the record, we did discuss your gut reactions. You know, I guess if the court is concerned about the plaintiff not being able to get at the jury's bias towards tort reform, then perhaps we could limit any reference to that McDonald's case to simply voir dire, and then it doesn't need to be referenced again at all at any other point in the case.
And I don't necessarily disagree with you on that at all. Why don't I ask plaintiff's counsel then, counsel?
Well, Judge, you know, I can't say that I'm in disagreement with that. I was thinking as I was writing the brief that this does go to a question of either conscious or unconscious juror bias that is often where we focus our questions during the voir dire selection process. And I don't see how I would relate the McDonald's coffee case in opening argument or closing argument, or the evidence that's been presented. I would anticipate there would be evidence about the fact that the coffee spilled on my client's leg and that he experienced severe pain as a result. I don't think we're going to hear any evidence about the actual temperature of the coffee. So I guess it would probably be jury selection.
All right, so you're not disagreeing then that it should only be mentioned in voir dire?
Correct.
All right, Mr. Robeson, you don't want it mentioned anywhere, correct? That's the bottom line.
Right. But in the interest of compromise and understanding where the court's coming from, I would request that if it were allowed at all, that it would be limited simply to jury selection to determine bias.
Right, and I would allow that in, but then I would further order that the plaintiff can't say award $3 million similar to what they did in this McDonald's case. That shouldn't be mentioned. It should be utilized with the tort reform type of mindset in mind. Any objection to that from plaintiff's counsel?
No objection, Your Honor.
All right. And then we get, I think, to the Dauber type motion. It's my understanding, Mr. Robeson, that you're arguing that this doctor, you're not arguing his qualifications, but you are arguing the causation link that he provides in the medical treatment to the spill of the coffee on the leg to the neck surgery. Is that correct?
Yes, essentially, Your Honor.
All right. And why do you think plaintiff's doctor should not be able to issue that opinion?
Sure. So again, Your Honor, just by way of quick background, the incident with the coffee occurs in January of 2016. Mr. Mutiva sustains a local burn to his right thigh. 3 years later, he goes and sees Dr. Lee, who's a neurosurgeon, to address continued issues with that he's experiencing with the thigh burn, continued ongoing pain. Dr. Lee discovers that he's having symptoms of cervical myelopathy, and he specifically testified that those symptoms were weakness in his arms and in his legs. And that was sort of an incidental finding as he was working up the thigh burn. And, he even showed us in his deposition the MRI imaging showing where the spine was, where the cervical spine was impinging on the cord and causing that weakness. And he said, yeah, I discovered that and I performed the surgery to address that neck issue and the cervical myelopathy. But he said specifically that surgery was not done to address any of Mr. Mutiva's thigh pain. But he said that in his opinion, because Mr. Mutiva came to his office initially to address the pain from the thigh burn, then the surgery must have been caused by the coffee burn, because why else would he have been in my office? Why else did he come to me? So that's just by way of quick background. Obviously, it's fleshed out further in the briefs. But he's relating a very expensive neck surgery to this coffee burn to the man's thigh solely because that was the reason he came to his office. And you're right, Your Honor. I'm not attacking Dr. Lee's credentials, and I'm not asking the court to usurp the role of the jury in finding whether or not he's credible. What we're asking is the court to exercise its function as the gatekeeper here to make sure that the information the jury receives from Dr. Lee is well-founded and relevant to the case. And I pulled a brief from Attorney Erdman's brief where he's citing the Seaford case. He says the trial court is to be a gatekeeper in ensuring that the proposed expert is qualified and that his or her testimony rests on a reliable foundation and is relevant to the task at hand. And so I think that's what the main point is that Dr. Lee's opinion on the issue of the surgery, it should be excluded because it's not based on a reasonable or a reliable foundation. Sorry, not reasonable foundation, because that goes to credibility, but reliable foundation. And it's not relevant to the jury's task, which is determining what treatment was necessary for the injury that was actually caused by the burn. And so I want to focus on that, Your Honor. And that's why I quoted the jury instruction in my brief. The jury's going to be asked, what sum of money it will be is reasonable and necessary for the care of the injuries sustained by the plaintiff as a result of the accident. It says it in there twice. You must determine whether the healthcare services were provided for the injuries sustained by the plaintiff as a result of the accident. So the relevant question for the jury is what injuries were sustained by the plaintiff and what care was given for those injuries. And at no point does Dr. Lee state that Mr. Mutiva sustained cervical myelopathy in this coffee incident. And that's important because the surgery, he says, was done specifically to address the symptoms of cervical myelopathy, which is weakness in his arms and legs. He specifically says that the coffee incident and the cervical myelopathy symptoms are not related. On page 22 of the deposition transcript, I asked him, you're not saying that the coffee incident was related to the weakness in his arms, are you? And his answer was, that is correct. I am not saying that. And on page 23, I said, are you saying that the coffee incident caused the weakness in both legs? And he said, no, I am not. So because Mr. Mutiva's claimed injury from this coffee incident was not symptoms of cervical myelopathy, then any treatment that was done to address the cervical myelopathy is not relevant to the jury's ultimate question in this case of what treatment was related to the injuries sustained in the coffee burn. Dr. Lee specifically says that the plaintiff's injury was pain in his thigh. And he specifically says multiple times in his deposition that the surgery was not done to address that thigh pain. And I cited at page 4 of our brief 3 specific instances where Dr. Lee admitted that he did not do the surgery to address the thigh pain. In fact, he even said, I would not have done the next surgery to address the thigh pain if he didn't have the cervical myelopathy symptoms. I didn't think it would work. So when the jury is asked what injuries were sustained in the accident, Dr. Lee's testimony is that it was thigh pain. And when the jury is asked to determine what treatment was given to address that thigh pain, the injury from the incident, Dr. Lee never says that the surgery was done to address the thigh pain. It was done to address the separate and completely unrelated issue of weakness in his arms and legs. So the fact that the next surgery was done is not relevant to the jury's question of what treatment was given for the thigh burn. And the cost of the surgery should never enter the equation because that treatment was not done to address an injury that Dr. Lee believes was caused by the accident. And so when we look at that Daubert standard that's discussed in the Seifert case, that's in the plaintiff's brief, it's clear that Dr. Lee's opinion is not on the neck surgery. It's not relevant to that jury's question. His opinion can be excluded on that basis alone, I believe. Now, I've read the plaintiff's brief. He attempts to argue that the cervical myelopathy was asymptomatic before the incident, and therefore it must have been caused by the coffee burn. But Dr. Lee never says that, and he never even comes close to saying that. Now, as a brief timeline, Your Honor, remember, Dr. Lee saw Mr. Mutiva before
counsel,
this.
let me just pause you here. I'm just looking at his report. This patient did not have these symptoms prior to the accident, and based on the chronicity of the symptoms in his previous neurologic exams, which have been documented prior to the injury, there is causality. In other words, he does find cause for the pain there. So that's where I think there's a disconnect, and that's because I agree with you that neck surgery should have happened, but the accident itself caused an injury to the thigh, which was exacerbated by his pre-existing condition, and that injury to the thigh was relieved after the neck surgery. Now, is that enough? That's that's where I have issue. Is that enough to allow for that opinion to come in? So in other words, the neck surgery had to be done either way. I would agree with you there, the weakness in the legs and the arms. However, it relieved a substantial amount of pain in the plaintiff's thigh as a result of that surgery being done, correct? With the doctor saying there is causality is the final indication as far as the pain in the thigh being relieved, right?
Well, I'm sorry, Your Honor. Are you referring to his first report or his second report?
I am looking at the report that was added in the exhibits. I think it's July 16th of 2019.
Okay, I think that's his first report. So sorry, Your Honor. Right. And so the question of what he meant by there is causality is why we took his deposition in the first place, because we didn't know if he was talking about causality of the myelopathy for which he had the neck surgery or the causality of the thigh pain. Now, in that that same letter, he discusses the fact that the surgery was to address the cervical myelopathy. I think it's near the top. It doesn't say that it's to address the neck symptoms. And in fact, again, I asked him that in his deposition multiple times, was it done to address the thigh pain? Dr. Lee said, he seemed surprised too that the surgery caused relief of Mr. Mutiva's thigh pain. And in fact, in one of the reports, I apologize, I don't remember if it's the first or the second one, he specifically expresses that he did not believe that he would have any relief of his symptoms from the neck surgery. So what he's really done is he's put the cart before the horse. He performed the surgery not having any hope or anticipation that it would affect his thigh pain at all. And then after the fact, because he had subjective relief of his symptoms, he says, well, I guess that there was some relationship there. But just because he had relief from it doesn't mean that the thigh burn caused the need for the neck surgery. And so again, focusing on what the jury is going to be asked, which is what treatment was done to address injuries caused by the accident. He's not saying that the accident caused that thigh burn. And so, and again, sorry, Your Honor, for sounding like a broken record, but he says multiple times in his deposition that the surgery was not done to address the thigh pain. So that's not treatment that was done to address an injury caused by the accident. So, Your Honor, I think I understand why the court has some hesitation in allowing it in, because the doctor, and I've read the testimony that was cited for you in the plaintiff's brief. It's very confusing, and I think his letters are confusing, which is why we needed to take his deposition to try and clear it up. But ultimately, when you get down to it, when you're having the jury listen to what he has to say, it's as simple as, I didn't do the surgery to address the thigh pain. The coffee burn did not cause the neck symptoms. And I did the surgery to address the arm symptoms, the arm and the leg symptoms. And that's what I did the surgery for. And so again, that's the relevant question the jury is going to answer. And I don't think the jury should be hearing about a neck surgery that's not done to address an injury that wasn't related to the accident or caused by the accident. That's really just inviting the jury to say, well, and this kind of goes in conjunction with what I was arguing with regard to the reference to the McDonald's case, Your Honor. They hear this giant number, $300,000 for a neck surgery, combined with the fact that, hey, this is McDonald's at it again with a coffee injury, and it invites the jury to put a big number on that verdict that shouldn't be there in the first place. They shouldn't hear about this surgery if it wasn't done to address the injury that's caused by the thigh burn.
All right. I thought there was additional language in the second report that addressed those issues. And here's the thing. So the plaintiff, you're saying, can't bring in the neck surgery, which relieved the thigh pain. And he also can't bring in the fact that the thigh pain would have continued for life, but for the surgery. You see what I'm saying? Because apparently this thigh pain was rather substantial until the surgery was done, correct?
Well,
or at least that's what he's claiming.
Sure. And that's, ultimately a point of contention between the two experts. And so, I mean, that is a question that the jury is going to have to answer, and they can do it without hearing about the neck surgery, because Dr. Lee is saying that this predisposition to neuropathy caused him to have chronic pain. And before he even did the surgery, Dr. Lee was of the opinion that that pain would be permanent. And even after his deposition, he said that, yeah, he's still going to have pain. So he can address his opinion about the chronicity and the permanency of Mr. Mutiva's leg injury without reference to the surgery or the relief that he had from it. And Dr. Lyons can express his medical opinion, which was that, no, there's no way that this local thigh burn caused a permanent injury. So that's where the jury is going to hear the two competing arguments from the medical experts and get to determine their credibility. And I think that can be done without reference to the surgery. And I think the reference to the surgery should be excluded for the reasons I've already said. It's just not relevant to their question about what injury is caused by this accident.
But isn't the fact that there was relief after the surgery further proof for the plaintiff that that it did tie to the spine and to the thigh all the way down to the spine and going up to the neck? Isn't that part of showing what this doctor said in his report? He said it was tied initially, but you're right. He didn't say that I knew that when I do this surgery that was going to fix his thigh. That's not what he said. I agree with you there.
Right, and he also said he didn't do the neck surgery for the thigh because he didn't think it would help anything. Really, that's the chicken and the egg question, Your Honor. I mean, Dr. Lee, when he wrote his second report, had the benefit of already hearing Mr. Mutiva's after the fact statement that subjectively it helped my pain, but he couldn't provide any sort of explanation of why that was the case. And he said, that's not why I did the surgery.
He said that's not why I did the surgery, but he said the surgery relieved the symptoms and it was tied into the symptoms, correct, in the end?
Yes, I mean, that's his opinion.
Which differs from yours, right? Differs from your expert. I totally understand that.
Right.
Mr. Erdman.
So, actually, Your Honor,
I'm sorry. Go ahead, Jim. Go ahead.
Yeah, I think one or two more points. I was talking about the issue of whether the cervical myelopathy was symptomatic before the incident, and Your Honor jumped in and had some questions for me there, but I wanted to point out, Mr. Mutiva had seen Dr. Lee in 2012. That was the last time he saw him after he had performed some lumbar surgeries, and then the next time he saw him was in 2019. The accident occurred in 2016. So there's a 3-year gap between the coffee burn and when Dr. Lee saw Mr. Mutiva the next time, and a 7-year gap between visits that in 2012 and 2019. And I had asked Dr. Lee if he knew when the arm weakness began. This is at page 21 of his deposition. And again, when he referred to that gap between 2012 and 2019, he said, I can't make any presumption of when it occurred during that timeline because I wasn't there. And I asked him that with regard to the weakness in his legs. And he said, no, because it's the same answer. So Dr. Lee never said that the coffee burn caused the previously asymptomatic cervical myelopathy to become symptomatic. And he admitted he didn't know when it started. All he knows is that it was in there somewhere between 2012 and 2019. And so, when you're referring to the letter about causality, that's what I was getting at with those questions. Can you say that this was something that was brought on? The cervical myelopathy was brought on by the leg pain, and he can't tell me when it started. He doesn't know that was the case, and that was the thing that he performed the surgery for. So, I mean, quickly in conclusion, Your Honor, we're not asking the court to judge the credibility. We're not asking the court to find that he's not an expert or that he lacks credentials. It's simply we're asking the court to exercise the gatekeeping function of excluding the statement that the coffee burn caused the neck surgery because it's not based on a reliable foundation. Saying that, well, that's the reason he came into my office in the first place is not a reasonable scientific foundation for linking a neck surgery to a coffee burn. And it's not relevant to the jury's question of what treatment was related to injuries caused by the coffee burn, because he doesn't say that the cervical myelopathy was caused by it. So those are the two reasons why I think the court can exercise its gatekeeping function and exclude that particular line of testimony.
All right, Mr. Erdman.
Thanks, Judge. So we have a couple of reports here, and in the first report, which you have already gone over with counsel, the initial opinion is causality, that the symptoms were related to the coffee spill. And he says in that report, and there was reference to this is the report where he says this, the surgery may help, but the probability is low at that time. And so I think that a lot of the colloquy between counsel and Dr. Lee during his deposition is Dr. Lee saying, look, I knew the surgery could help his cervical myelopathy, but that's not the reason he came to see me. I discovered the cervical myelopathy when he did come to see me because of the symptoms related to the coffee spill. And that's what was significant. Those symptoms were what were bothering Mr. Mutiva the most. And then if you go to his second report, he specifically says in his opinion that the neuropathy or the neuropathic pain was made worse due to his pre-existing cervical issues. And so the problem I see with the argument that defense counsel is making is, especially given this timeline, is that we have a 2016 coffee spill. We will have a doctor who treated him opining that he saw him in 19 about this spill, and the jury is left wondering, well, what treatment did he give him, and why did the symptoms suddenly get better? And so then it's raising a question of credibility, reflecting back against the plaintiff himself. And I think that's unfair and prejudicial. The jury needs to see the whole picture, and they need and draw their own inferences and conclusions from all of the evidence. And the fact is that he did get better after he had the surgery. And the doctor agrees that the surgery helped that condition. And in that same second report, the fact that he says that it was made worse, he was talking about the cervical myelopathy intensified the symptoms. And so there's a relationship. There's your causal relationship. The cervical myelopathy intensified the symptoms. And when he then corrected the cervical myelopathy, the symptoms were then decreased substantially. And so the jury needs to understand that. They need to see that there is this causal relationship between the surgery and why he was seeing them in 2019. Otherwise, they're just going to be left hanging there wondering why. And they're going to blame the plaintiff for it.
All right. The court is going to allow in the doctor's testimony as it relates to this. Well, I understand defense counsel's argument. I think the doctor has tied this a little closer than what Mr. Robeson is giving him credit for. He is indicating that with that pre-existing condition, this plaintiff was weakened to some extent. The coffee spill, and counsel is going to have his expert, and I'm certain he's going to go into in-depth cross-examination of this doctor when the video dep is done. But he can bring out the concerns about the doctor's tie to causality as far as this surgery. But the court is going to allow the doctor's opinion to come in. I think he does tie it enough for it to at least get past the gatekeeper here. While I understand Mr. Robeson hasn't challenged the qualifications of this doctor, he has challenged the doctor's ability to tie the neck surgery to this case. I think he's done enough at least to get in the door. But I'm sure counsel's going to have a number of questions for him once we get in that door. All right, we have a trial date set, don't we?
Yes, Your Honor.
That's in March, I believe. So what I do require, and don't know if we talked at the pretrial, is that the parties submit to the court written jury instructions 2 weeks in advance in Word format. And not just the numbers, the entirety of the instructions, the ones that they agreed to, the ones that they don't agree to, and they want to submit their own, plus the verdict forms proposed by each side in Word format also. And that should be done 2 weeks ahead. Currently, and now this is where I'm late for my noon meeting to open up the new Utah jury trial courtroom, which is a Zoom type courtroom where the jury is in one courtroom and the parties and the judge are in the other courtroom across the hall. So that's going to be one option in March. The other option is the in-person courtroom where the jurors are in plexiglass, they're all surrounded by plexiglass. So I know in March that's likely to be the same scenario. I'm hoping it isn't. I really do hope that we can get into a nice live courtroom. I think everybody misses that to an extent. But I want the parties to be aware that those are the two courtrooms that we will have available to us. Everybody in masks, and if this scenario stays the same, and I'm hoping these inoculations that are coming up change that, but just so the parties are aware, those are the two courts that we have available in civil courts right now. It's one where everybody wears masks and is in plexiglass, or the second one where we do it by Zoom basically across the hall. So I just wanted to let you guys know that.
And
Judge.
Your Honor, are they stacked? Is there a potential that this case could get bumped for an earlier numbered case?
They are stacked.
Okay.
However, what I will say is last year we did about 1.2 to 1.3 trials per week. That was the average. Now there were weeks when we did 4, there were weeks when we did none, but typically the most you would have is 4. Thus far during the pandemic, as we've opened up the jury trials, we've only had 1 trial bumped so far. Okay. All right, we will do a pretrial. Mary, you want to set that pretrial date a couple weeks ahead so that we can, and then what happens is the judges meet 10 days before the trial to see which one is number 1 and number 2 and such, and then we'll inform the parties immediately.
So we could do February 19th, which is a Friday at 11:30.
Works for me.
Just a second.